A settler leaves £300,000 on trust for 3 children, Xavier, 23, Nina, 20, and Lucy, 19. The trust contains a specific condition. They must reach the age of 25 to inherit. Xavier is 23. He is legally an adult, capable of managing his own affairs, and he wants his share of the cash immediately. This creates a direct conflict with the settler's instructions. Can Xavier legally compel the trustees to collapse the trust and hand over the money, defying the express 25-year timeline? Answering this requires looking past standard contract law. We have to deconstruct the architecture of the English legal system, moving away from rigid common law rules and into the realm of conscience. The trust operates as a deliberate, divided mechanism. Dismantling it requires navigating the historical rules of equity. While the term trust often suggests private wealth, these structures govern massive segments of everyday life, including how public charities operate. They also anchor the corporate world. Trusts are the specific tool used to protect employee pension funds from corporate insolvency or fraudulent directors, an application heavily reinforced after the misappropriation of funds in the Maxwell scandal. To understand how they work, we have to look at their origin. Historically, the common law courts offered a limited, rigid set of causes of action. If your dispute did not fit perfectly, you had no remedy. The king delegated these unresolvable petitions to the Lord Chancellor, who developed a parallel system called equity, intervening specifically when good conscience demanded a fair result. By the 19th century, this separate Court of Chancery had developed its own severe problems, becoming notoriously slow and inflexible, flaws sharply critiqued by Charles Dickens in his novel Bleak House. The solution arrived via the Judicature Acts of 1873 and 1875. These acts fused the administration of the courts into one Supreme Court. Today, any judge can hear both common law and equity cases, but the distinct legal doctrines of each remain intact. Because equity acts specifically on the conscience of the individual, it allowed for the creation of a unique concept that the common law courts could not comprehend: dual ownership. This dual ownership forms the anatomy of an express trust. It involves 3 specific parties. The settler creates the trust, transferring a central asset to the trustee, who holds it for the beneficiary. The trustee takes on the management role. They hold the legal interest. To the outside world, banks, registries, and corporate boards, the trustee is the absolute owner of the property. The beneficiary, meanwhile, holds the equitable interest or beneficial interest. This grants them the true proprietary right and the actual enjoyment of the asset. A warning for your exams. Examiners will penalize you if you simply state that a beneficiary owns the trust property. You must specify that they hold the equitable title. Because the trust relies entirely on this separation, a rule of merger applies. A sole trustee cannot hold property on trust solely for themselves. If the legal and equitable titles unite in one person, the trust ceases to exist. The entire power of a trust, and Xavier's ability to legally access his £300,000, hinges on this deliberate separation of control and benefit. Because equity operates on conscience rather than strict contractual terms, its rules are governed by broad principles called maxims, rather than rigid automatic triggers. One crucial maxim is, he who comes to equity must come with clean hands. This requires a claimant seeking an equitable remedy to have acted fairly themselves. We apply these maxims using the IRAC method: issue, rule, application, conclusion. Consider Argyll versus Argyll. The legal issue was whether the Duchess of Argyll's known adultery barred her from receiving an equitable injunction to stop her husband from leaking confidential information about her. The rule states that the unclean conduct must relate strictly to the specific legal dispute, not general morality. Applying this to the facts, the court found her adultery was legally irrelevant to her husband's breach of confidence. The conclusion: the injunction was granted. This proves that equitable maxims require a precise, legal application of conscience, not just broad moral judgments. Returning to our initial problem question, to determine if Xavier can take the money now, we must strictly categorize his specific equitable interest. We do this by mapping it across a 3-axis matrix: The first axis differentiates a vested interest, which has no conditions attached, from a contingent interest, which depends entirely on a specific future event occurring. The second axis separates an interest in possession, granting immediate enjoyment of the property, from an interest in remainder, where the beneficiary must wait for a prior interest, like someone else's right to income for life, to expire. The final row populates with absolute, capital, and limited, income. Now we map Xavier's position. Because he must reach age 25, his interest is contingent. Because he does not have to wait for anyone else to die first, it is in possession. And because he gets the actual cash, it is absolute. Xavier holds a contingent, absolute interest in possession. With his interest defined, we apply the 1841 landmark case, Saunders v. Vautier, which serves as the ultimate test of a beneficiary's power to end a trust. This logic gate maps the strict rule. Beneficiaries can collapse a trust only if all possible beneficiaries are in existence, ascertained, in agreement, and sui juris, meaning of sound mind and over 18. Applying this to our three siblings, Xavier is 23, Nina is 20, and Lucy is 19. They are all legally competent adults, so they pass the first phase of the test. But the analysis hits a critical sticking point regarding absolute entitlement. We have to ask a severe question. What happens if all three siblings die in an accident tomorrow, before any of them reach the age of 25? Because their interest is strictly contingent upon hitting that age, if they die early, their interest fails. The property would then revert to the original settler's estate via an implied mechanism called a resulting trust. This brings us to the conclusion of our IRAC analysis. Because the settler's estate retains a potential future interest, if the contingency fails, the three siblings do not represent all possible beneficiaries. Pay close attention here. A frequent error on exams is misapplying this rule to contingent class gifts. You must always check for the possibility of a resulting trust if the condition is not met. The final answer is clear. Xavier cannot force the trustees to hand over his share. The logic gate is locked, and the settler's age 25 condition holds firm. Equity governs territory outside of trust management. It intervenes specifically when the common law's default remedy of financial damages fails to address the underlying wrong. One such intervention is the injunction. This is a targeted court order that either forces a party to perform a specific act or stops them from doing something irreparably harmful, like destroying protected land. Similarly, a court can order specific performance, compelling a party to physically fulfill the terms of a contract. This is particularly useful in transactions for unique items or real estate, where a monetary substitute is impossible. Equity also provides the power of rectification. A court will correct a signed, executed document if it mistakenly fails to reflect the actual proven intent of the parties involved. None of these actions exist at common law. They are pure inventions of equate, designed to actively enforce fairness rather than simply calculating a financial loss after the fact. This brings us to a final equitable remedy, rescission. This is the power to tear up a contract and return all parties exactly to their pre-contractual state. Looking at the Supreme Court case of Pitt v. Holt, Lord Walker defined the precise rule. Rescission is available for mistakes regarding the legal character or nature of a transaction, not just an error in judgment. Remember that all of these remedies, from injunctions to rescission, are entirely discretionary. If a claimant demonstrates unclean hands or an unreasonable delay in bringing the claim, known as laches, the court will deny the remedy outright. This entire framework circles back to a defining principle laid down by Lord Brown Wilkinson in the West Duchy case, the common unifying thread of all equitable intervention. Whether we are classifying a strict contingent interest to stop a 23-year-old from collapsing a family trust, or issuing an emergency injunction to halt a bulldozer, the legal architecture is identical. Equity operates exclusively on the conscience of the legal owner.